This is the divorce education series presented by Findling Law. On this topic, we're going to discuss property division. This is a pretty complicated area of Michigan law. I'm going to give you a lot of general rules that are going to apply to 90 some odd percent of the situations. But there are also a lot of exceptions to these rules. As a result, it's inevitable that you're going to have questions. We want to be here for you, so we've made it easy for you to contact us. At the end of the presentation, I'm going to provide you both my direct number and email address. Of course, on the website, there's also various mechanisms by which you can contact us. So when we discuss property, we need to have some definitions. Not only what is property, but what do we divide, how do we divide it? And we classify property really as two types, marital and separate property. Having a basic understanding of these terms will help you navigate your divorce. So let's get to work. Property are anything with a positive or negative value. If it's an asset, it's property or a liability. So this real broad definition of property, just about everything is considered property if it has a positive value or negative value. If you owe money on it, it's a liability. We consider that property, and we treat it essentially the same as we treat an asset, that is property with a positive value. Now we classify it as two types. Real property is land, and personal property is everything else. And personal property is very broad. You can read on the bottom of the slide everything from bank accounts to retirement accounts, credit card collector, record positive or negative value is considered property. So what do we divide in a divorce? What property is divided in a divorce? And the answer is marital property. Let's define that, okay? By reason of the marriage, okay? Property acquired by reason of the marriage or during the course of the marriage. So we have really two periods of time, the date of marriage and the date of divorce. If property was acquired during that time frame, we consider it marital property. What about property acquired when you were living together? What used to be called common law marriage? Not in Michigan. The Reeves versus Reeves case says that as a general rule, property acquired during cohabitation or what used to be considered common law marriage is not marital property. Now I want you to remember this because there are some sub-exceptions to this rule, instances when property acquired during cohabitation can be considered marital property, but the general rule is that it's not, okay? Another key variable that courts often struggle with and lawyers like to struggle with is when a marriage actually ends. In other words, does it end when you separated or did it end when you actually get divorced? The majority view under Byington versus Byington is that at the entry of the judgment of divorce, that's when your marriage ends. Now, under many instances, though, it's when you separate. Now, the legal term is when you manifest an intent to live separate lives. That's fancy legalese for saying when you separate. Now, that's the Wilson rule. This can become very important. Let's take, for example, that you've been separated for a couple of years and the marital estate has gone up a lot or gone down a lot. Well, then maybe the divisible estate, the marital portion, the marital property is either larger and smaller. And depending on who you're representing or what your interests are, maybe you want that estate smaller or maybe you want that estate larger. And you can really get into some vigorous debates and argument as to whether or not you use when the parties separated or manifested an intent to live separate lives or at the date of entry of the judgment of divorce. It's important to understand that the majority of you, under the majority of circumstances, we use the date of the judgment of divorce as the division date, not the date of separation, but we also use the date of separation in limited cases as well, okay? For instance, take for example, you can you know, 15 years or 20 years, or sometimes even shorter than that. All right, so What property is not divided in a divorce? This almost answers itself. If marital property is property that is divided during a divorce, separate property is going to be property that we do not divide. Okay? Now, what is separate property? The slide on the screen sort of defines it for you. Before the marriage or after the divorce. Okay? So separate property. That's a doctrine. The doctrine of non-evasion of separate property. This is, I believe, Byington and Reeves talks about the doctrine, and classified in other cases as well, but essentially stands for that proposition that if we label the property separate property that is acquired before you were married or after the divorce, we are not going to divide it. Now, there are going to be instances where property is going to have a separate component and a marital component. Take a 401k. Maybe there was $50,000 in the 401k as of the date of marriage, and now there's $100,000 in the 401k as of the date of divorce. Well, that first $50,000, first the date of marriage, as of the date of marriage, is going to be considered separate property. But that increase in value under most circumstances is going to be considered marital property, and we're going to divide it. Some exceptions to the doctrine of non-evasion of separate property. There's two. Okay, the first one, remember a minute ago when I said, what about premarital contribution, or while you were living together, cohabitating? Well, if it's readily traceable, for instance, you have a home and you purchased the home before you got married, while you were cohabitating, if you will, and your spouse put $50,000 down on the home, and they can trace that they put this from their bank account or their savings account. But the home is only in your name, for whatever reason. And now you're getting divorced. You subsequently married and you subsequently divorced. And one party is arguing, listen, property acquired during the course of the marriage, the home was not acquired during the course of the marriage, therefore it's separate property. Well, this exception would apply under most circumstances. That is, the premarital contribution, that $50,000 down payment, is marital, and the home then becomes marital and then can be divided. Now, the other exception is a little bit less common. That is sort of a poverty exception. If the only asset of the marital estate are separate assets, that is, there is nothing else, public policy sort of kicks in, and the legislature said, wait a minute, if we have an option of an individual becoming a ward of the state that is going on welfare or getting the separate property of their spouse, regardless of how long or short the parties have been married, let them take the separate property of the spouse if it can avoid potentially them going on welfare. So the second exception to the doctrine of non-evasion of separate property is if the only thing left is separate property. There is no marital property. Under that circumstance, you can invade separate property, okay? The doctrine of non-evasion of separate property, okay? So we divide marital property. We do not divide separate property, okay? This is an important point that skilled lawyers apply other exceptions to these general rules. We talked about some of them. Let's talk about others. Active versus passive appreciation. In that 401k example I gave you just a moment ago, that appreciation, that $50,000 that you had in the 401k before you got married, remember, that grew to $100,000? We consider that growth active appreciation because with 401k, an administrator of that 401k is buying and selling stocks or taking fees or whatever the case may be, and that's often considered work. And therefore, we call that gain active appreciation and therefore marital. What if the gain was passive? For example, you had $50,000 in a certificate of deposit, and during the course of the marriage, it is now $100,000. But you didn't do any work. You just left it in the bank. You left it in the certificate of deposit. That passive appreciation does not become marital. It remains separate property. And in that situation, that $50,000 gain remains separate property. So a skilled lawyer is going to try to identify to their client's advantage whether it is active appreciation or passive appreciation, or not raise it if the situation so requires. What about gifted or inherited property? This is another common exception. When property is gifted or inherited during the course of the marriage, well, it's marital property, right? Well, not exactly. There's a case called Dark versus Dark and some other cases as well that stand for the proposition that gifted or inherited property during the course of the marriage moves from the marital column and travels to the separate property column. In some instances, it can travel right back if it's commingled, and commingling assets is another exception. All right, what do I mean by that? Well, let's say that you had $50,000 once again in separate property, let's say in a bank account. Let's make it easy. Prior to you being married, and then you took that $50,000 and you put it into a house during the course of the marriage, and you sold that house and you bought another house and you financed that house, maybe took some cash out, and now it's no longer readily traceable. You no longer can say, well, wait a minute, this $50,000 came from my savings. And the other party says, well, wait a minute, we bought a house, we sold a house, we bought another house. It's been so commingled that it's no longer readily traceable. In that situation, separate property can become marital property. Now, there are also some new exceptions to this rule that sort of put an asterisk on this. The Cunningham versus Cunningham case, we're not going to discuss it in great detail, but often even property, real property or land that was separately held and separate gains can often be considered marital just because of the length of marriage. It's sort of an outlying case here, so there are sub-exceptions to the exceptions. But it's important to note in the majority of cases that the rules that I'm applying here, the marital property rule is what we're going to divide, not separate property, is going to apply in almost every case. The exceptions really are just that, narrow exceptions. Tax affecting assets and liabilities is less of an exception and more of a technique. What skilled lawyers try to do is recognize, well, maybe my client is in a 40% tax bracket and their client is in a 15% tax bracket. And if we're awarding an asset, what tax effect, what is the cash that's actually passing through to your client? And is it the same cash? Do you treat 401k dollars the same as cash in the bank account? You better not if you're a skilled lawyer, because 401k dollars are pre-tax dollars and cash in a bank account are post. Okay. Now with liabilities, there's another rule as well, and that deals with how is property divided. Okay. And we'll talk about that in just a minute. Okay. As it relates to marital property, that's the property that we divide, fair. It must be fair. There is nothing in Michigan law that says that it must be a 50-50 division. Rather, the division must be fair. Key factors are source, contribution, the length of the marriage, what are the parties' needs, right? The earning ability of the parties, the cause of the divorce, the age of the parties, and the health of the parties. These are the Sparks versus Sparks factors. They're readily available online. There's some other statutory factors as well that we're citing here. But it's important to notice the cause of the divorce. Oftentimes people get confused and they think, well, we're a no-fault divorce state. That only applies to why we're granting the divorce, not for property division or even custody cases. Now that's for another topic. Fault can clearly play a role in property division, in alimony cases, and most definitely in child custody determinations. Fault can also play a role. So just because we're in no fault state does not mean that the cause of the divorce or the fault of the parties is not relevant with regard to how property is divided. Now, it's also important to note that with liabilities, I was talking about that just a moment ago. Just because a liability was acquired during the course of the marriage, there's an exception to that rule as well. I probably should have talked about that on the other slide, but let's talk about it now. That exception is the debt must have a marital purpose. So if you have a credit card debt, let's say a liability that was acquired during the course of the marriage, and it was used to fund a failed business, well, that's marital. Or vacations, that's marital. But what if it was used to perpetuate an affair, or for a gambling debt, or for drugs or alcohol, because the individual is an addict? If the liability cannot be attached to some marital purpose, it becomes the separate liability of the party. That's another exception that must be noted, that as we treat liabilities, maybe with a little asterisk differently than we do assets when it comes to how we divide property. Okay? So marital property must be fairly divided, and there's no set formula. We talked about that. There's nothing in Michigan law that requires an equal division. Okay? This slide's a little bit wrong. It should say that requires an equal division or a 50-50 division. There's nothing in Michigan law that requires an equal division. It must be a fair division. Let's take some examples. I'd like to demonstrate sort of examples on the extreme, because no one's really on the extreme. Everyone's sort of in the middle. Let's say that you have a 30-year marriage as a hypothetical client, no children, and an estate value of $1 million. In this marriage, there's nothing extraordinary about it. They just fell out of love. They decided it's time to go our separate ways. They lived a nice life together, but at the same time, they fell out of love. No one's at fault. Nothing extraordinary there. What's a fair division under those circumstances? Well, most likely a 50-50 division, right? It's fair. They were a loyal husband, loyal wife. They just fell out of love. No one's at fault. They probably have the same needs. They're not retired, whatever the case may be. So each party is going to get $500,000 and move on. Well, let's change the fact. The fact that we're going to change is that they've been separated for 29 years, all right? And they haven't seen each other. Maybe they got married in Vegas. They both live in Michigan, but they just haven't seen each other. Never lived as husband and wife. The marriage was a sham, and the husband is worth nothing. He's a pauper, and the wife is worth $1 million. She's had a successful business. How is property going to be divided there? Is the husband going to be able to make a claim for that $500,000 or half of the marital estate? Now remember, there's nothing in Michigan law that requires an equal division or a 50-50 division. It must be an equitable division, a fair division. And more likely than not, the wife is going to keep her $1 million and the husband is going to get nothing. Because under this circumstance, it wouldn't be fair to give the husband any part of the wife's estate. Now, of course, I'm not just picking on husbands here. The wife, if the situation was reversed, it would work the same way. If the wife had no money and the husband had $1 million, it's a two-way street here as it works to what is fair, what is equitable. Okay. Now, of course, I like talking about skilled lawyers. We talked about tax-affecting assets, different tax bases, and so forth of the parties. What about valuation methodologies? It's not uncommon that you have a business associated with a marital estate, right? Maybe a doctor's business or accounting business or a lawyer's business, or even a mom and pop shop, or landscaping company. Well, is that marital or is that separate? Well, the same rules apply to businesses as anything else. It's an asset if it was acquired during the course of the marriage or increased in value during the course of the marriage. But let's say that we don't have a division question. That is, we know that we're going to equally divide, because of this marriage, the business. But how do you value the business? Well, valuing the business can become very important because there's different valuation methodologies. Do you use book value? What's on the books? Do you use market value? What it could sell for to a third party? Or a going concern? What about enterprise goodwill versus personal goodwill? How is that treated differently? All of this is highly relevant, and skilled lawyers sometimes spend more time arguing over methodologies than they do about division. Because if you're giving half of nothing, well, that's pretty important versus half of $1 million. And oftentimes, the methodology, the business valuation methodology, can dictate which is the most appropriate. Value. Okay, which number are you using? Remember, the rules that we provided here in almost every circumstance. If you have a question after this webinar is done, what about this? What about that? Was it marital? Was it separate? Now, of course, there are lots of exceptions, but the exceptions generally don't apply. The majority of the cases are resolved just by saying, is it marital or is it separate? It is always inevitable in every instance when I give this talk on a one-on-one case during a consultation that you're going to have questions. So I've made it easy for you to contact me. My direct number is 877-968-7347. That's 877-YOUR-FIRM. It'd be a privilege to talk with you. be happy to answer any questions that you might have. Of course, you can always email me. My direct email address is daniel@findlinglaw.com. Daniel@findlinglaw.com. Also, that phone number, it spells out your firm. So if you don't remember after you leave the website, it's 877 your firm. I want to thank you for the opportunity to listen to me. I know this can sometimes be considered a pretty dry topic, but it's also important for you to understand, as you or your loved one is going through something as complicated or as difficult as a divorce. I really believe that the more that you're empowered, the more that you understand the process, the better equipped you are to deal with the situation. So thank you once again, and feel free to contact me if you have any questions.